26(1) of the Constitution would require that the applicant is admitted to bail and released accordingly. In reply, the prosecution opposed the bail application on the following grounds. First, it was their submission that the accused person had not provided her national ID or passport to the court, as required in paragraph 12 and 13 of the bail guidelines. It was her fear that the accused could flee the country and the territorial jurisdiction of the court. As regards the argument that the accused is of advanced age, the prosecution argued that the fact of being advanced age did not entitle one to mandatory bail from the court. Bail remained at the discretion of the court. Third, the information of what transpired about the raid by state agents was, in short, evidence from the bar, and there was no iota of evidence to prove the same. Rather, the prosecution argued that the very fact of raiding would mean that the accused is a fugitive on the run with no fixed place of abode, since she is in hiding. Fifth, as regards the sureties, the prosecution argued that the fact that the accused person did not know the surety's residence contradicted the fact that they were her friends well known to her and able to compel her to come to court, or for the state to trace the sureties should the accused person abscond. Sixth, to her, some of the sureties had not been truthful by giving wrong phone numbers, such as surety 1, Honorable Luzira, and surety 4, Godbert Mushari. She also expressed fear that the duty station in terms of the constituency of surety 1, Honorable Lucia Kello, in Amuru, is too far for the surety to monitor and compel the accused person to attend court. Lastly, as regards the medical report, Police Form 24, which I will refer to as PF 24, she submitted that the form had been disowned by the accused, who had denied being examined upon it. She found it unbelievable that the same counsel for the applicant would rely upon the same as proof of ill health. To her, such ill health had not been proved and, in short, should be disregarded as a factor in the consideration of the bail application. In conclusion, she attacked the character of the accused person in court, who seemed uncourteous and rude in answering questions put to her by state prosecutor during her reply, in her attempt to determine the substantiality of the sureties. She also argued that these answers show that this person is likely to continue with saying such words that are already complained of in the current criminal matter. All in all, she prayed that the bail be denied. Rejoinder. In rejoinder, counsel for the applicant tackled the issues raised in reply by the prosecution. First, counsel argued that the state had skipped paragraph 13, A and E of the bail guidelines, which provide for the consideration of the gravity of the offense and the applicant's age and physical condition. As regards the ID and passport, counsel noted that failure to tender these in was an oversight, and tendered in the ID and showed court the original passport. As regards reliance upon Police Form PF 24, counsel argued that the prosecution was, as it impairs, and that it impairs the presumption of innocence. Further, argued that such denials should be based not on mere allegations. Counsel also submitted that the variance in the name reflected in comparison with the phone numbers provided by surety 1 and 4 was due to one error in transcription of the numbers of the surety. The first was an error of the prosecution, and the second by counsel for the applicant. The correct numbers were provided. In conclusion, counsel argued that the factors to be considered for bail are in paragraph 15 of the guidelines, and the substitutions of the state are not included therein. All these arise from the Article 23 of the Constitution, which we call the random, which implies the word may, implying the use of discretion of the court. The counsel, this gives the court a wide discretion which should be judicially exercised. Counsel also reiterated that the accused has a fixed place of abode and is a married woman who has no intention of abandoning her fixed place of abode in Lake Drive, Luzira Parish. I reiterated the earlier prayers for this court to allow the application. Consideration and determination of this application. I've carefully considered the submissions by both sides, land counsel for the applicant and land counsel for the state, which I will not reiterate. I have also read and analyzed the cases quoted and the law as a whole, albeit that the time was relatively short. I was, however, able to appreciate the vital elements in the arguments of the two parties, and I am grateful for their preparation and spirited arguments presented to court today. These enable the court to arrive at a decision that is supported by the law and the evidence. The nature of bail. The decisions cited were clear on bail provisions. I will only summarize their content. Originally, bail means security given to court by another person that the accused will attend trial on the day appointed. This is the alternative argument of accused counsel. It also includes recognizance entered into by the accused themselves, conditioning them to appear, and failure of which may lead to a warrant of arrest and confinement in prison till the trial of the case is heard and finalized. This reflects the primary argument of bail by the accused person. However, in both these instances, bail may also lead to forfeiture of the recognizance by the accused or applicant and even the sureties, whereby they are ordered to deposit the money they were bound to court. Bail is granted to an accused person to ensure that he appears to stand trial without the necessity of his being detained in custody in the meantime. The effect of bail is merely to release the accused from physical custody, as has been held in the cases cited, but he is still under the jurisdiction of the law and is bound to appear at the appointed time and place. What is the basis of bail? Indeed, as a long-recognized principle under the criminal law, bail is premised on the presumption of innocence in Article 28(3)(a) of the Constitution, and the case law under that needs no restatement in terms of precedence, as it has been subject to numerous applications in the course of record. It's also premised on Article 23(1)(a) and 23(6)(a) of the Constitution, which grant court the right to grant bail in its discretion with conditions it considers necessary. In the observance of the personal liberty of each citizen. In the magistrates' courts, bail is additionally governed by the provisions of Section 75 and 77 of the Magistrates' Court Act, Chapter 19. This application is made under Section 75, where it is provided that, and I quote, the magistrate's court before which an accused person appears or is brought charged with any offence may, at any stage of the proceedings, release the person on bail on taking from him or her a recognizance consisting of a bond with or without surety for such an amount as is reasonable in the circumstances of the case to appear before the court on such a date and a time as is named in the bond. And underline may at any stage of the proceedings. So it is discretionary at any stage. The discretionary nature of bail. Whereas Article 23(6)(a) of the Constitution and Section 75 of the NCA allow the applicant to apply for bail, the grant of that bail is not automatic. For that, you see the case of Foundation of Human Rights Initiative, that is Attorney General, Constitutional Petition number 20 of 2006, Council for the applicant provided. All the provisions of the law I have quoted use the expression may, which means that court is given or left with discretion to grant or refuse. Indeed, as has been noted, you must always be borne in mind that where any legislation confers court upon court discretion to do anything or grant a relief, such discretion has to be exercised without any malice, without any ill will, ulterior motive, or regard to external influence or circumstances. The court must be satisfied that the provision of the law has been complied with. For that, in part of the case, the judgment of the ruling of Masar Musene, the judge as then was in the case of Kano retired Peter Destia versus Uganda, criminal application under 83 of 2016. The details can be read. The exercise of discretion in the grant of bail essentially entails the consideration of the conditions set out in the law that court must consider whether or not to grant bail. Article 23(6) of the Constitution provides, where a person is arrested in respect of a criminal offense, A, that person is entitled to apply to court to be released on bail, and the court may grant bail that person bail on such conditions as the court considers reasonable. Such conditions as the court considers reasonable. Section 77 of the MCA also provides for the discretionary powers of the court whether or not to grant bail to the accused person. In doing so, the considerations to be taken into account by the court include 1. The nature of the accusation, 2. The gravity of the offense charged and severity of the punishment, 3. Antecedents of the applicant so far as they are known, 4. Whether the applicant has a fixed place of abode within the area of the court's jurisdiction, 5. And whether the applicant is likely to interfere with any of the witnesses of the prosecution or the evidence written in support of the charge. I take note that these provisions are mirrored in the Constitution bail guidelines for the courts of judicature, practice direction, which again I will not reiterate here. I will go ahead to consider these factors so far as I find relevant. 1. The nature of the accusation. In agreement with counsel for the accused, the offense is not one of the personal physical violence as to endanger other members of the community. It also has an aspect of freedom of speech, which in light of the presumption of innocence requires a balancing act. Here, court is invited to determine that if that right was used contrary to section 38(1)(d) to promote sectarianism. Here, in the criminal case, the court is invited to determine if that right was used contrary to section 38(1)(d) to promote sectarianism. What I mean freedom. What I mean freedom of speech. It's a bail application. So I agree that the consideration of bail, when such rights are in play, should be carefully weighed against the public risk. In this case, no such risk caused by the nature of the offense is cited. However, if bail is granted by this court, the accused would be cautioned to limit such utterances similar to those now in court and pending proof to avoid potential commission of other offenses during the period the matter is pending hearing. Gravity of the offense charged and severity of punishment. The offense charge involves the use of words, printed or uttered, or any act of hostility towards the group of people. The penalty is a maximum imprisonment of 5 years. This is not so grave as compared to the capital offenses, as I indeed noted in the previous case. The prosecution will not dispute this, and the fact that it is covered under paragraph 13 of the bail guidelines in section 77 of the NCA. The prosecution will not dispute this, and it is also covered under paragraph 13 of the bail guidelines in section 77 of the NCA. As already noted, the only catch that I need to restate here is that this person should refrain from engaging in any sort of act similar to those complained of during the hearing of the matter. The third is antecedents of the applicant so far as they are known. Antecedents are important in a bail hearing. Indeed, as Masam noted, it would be a mockery of the judicial process and a miscarriage of justice if bail is granted to a person who has a staggering record of previous convictions to his name. In the present application, it has been elaborated by counsel for the applicant that there are no previous convictions. and the applicant intends to religiously attend court in this matter. Counsel set out the flowery code of service of the accused person and the distinguished offices she has held over the years to show her good conduct. Again,